Good morning. I'm going to pick up where Professor Parker ended, which is to talk about prosecuting corporations criminally, and his observation that there is very little statutory or Supreme Court case law that gives you guidance as to the standard that should apply in such prosecutions. I came to this topic in a very unusual way. First as a prosecutor, where I worked reporting to Alice Fisher to my left on the Arthur Andersen case as a prosecutor, and then worked on several deferred prosecution agreements with large financial institutions, Merrill Lynch and CIBC. And I probably am the embodiment of something that George Bernard Shaw said, which was, everything I do makes a mockery of everything I say, which was, after I left the government, I had been thinking about what is the genesis for the current state of the law with respect to prosecuting corporations. And as we all know, in virtually every federal circuit, the standard is extraordinarily easy for the government, which is that it only takes one. All you need is one employee who has acted in part to benefit the company and has acted within the scope of her employment, with the scope provision being interpreted very loosely. It is not a defense in any circuit that the corporation had the most robust corporate compliance program and had taken all actions to try and prevent the criminal conduct of the employee. So one of the things that I had been thinking about when I was on the Enron task force was the following hypothetical. When one thinks about Arthur Andersen and Enron and Merrill Lynch and CIBC, I thought, well, what about the next generation of corporations? What if you had a corporation that was the model corporate citizen, that did everything right, that none of us could think about any corporate compliance measure that they had not taken? And in spite of that, as will happen in any large corporation, an employee commits a crime, tries to inflate the numbers of that company. Criminal liability attaches. Whether it's prosecuted or not is another matter. But the state of the law is that that corporation has committed a crime. And that struck me as highly unfair. And I went and spent my time between the government and private practice writing a couple law review articles on this and looked at the genesis for corporate criminal liability. There are very few federal statutes that actually have respondeat superior embedded in them. One is the Elkins Act, which I'll return to in a few moments. But usually, a federal statute, the ones that you're familiar with, just define what the crime is and make it clear that a corporation, like a person, can be liable for that crime because a person is defined to include a corporation. But exactly how a corporation is liable is not set forth in any congressional statute, which itself leads to many, many questions that you all may have because, of course, in the federal system, you usually look directly to a statute to figure out what the crime is. And the next issue was, well, the Supreme Court must have ruled on this. Well, they didn't. And it's great to be here because it's literally 100 years ago this year that New York Central was decided by the Supreme Court, and I submit has been roundly and widely misinterpreted by federal district courts and courts of appeals. That case involved the Elkins Act, where the statute that Congress enacted said that respondeat superior applied, and that the corporation could be liable, and you impute the liability of the corporate actor, the employee, to the corporation. So it set forth the exact standard. And the issue before the Supreme Court was simply whether Congress had that authority. And the court said yes. It didn't say one thing about whether that applied necessarily as a matter of federal common law when the statute was silent. And for a while, circuits did not interpret it in the expansive way, but now it has been. And as I mentioned, there isn't any circuit that hasn't taken a very broad view of corporate criminal liability as a matter of federal common law. The issue for if you go back to my hypothetical, the problem in terms of the analysis when you're thinking about criminal liability versus civil liability is criminal liability is not usually about redress. It's not about the focus of what we all know civil liability is for. And for the corporation that is the model corporate citizen, if you look at the goals of corporate criminal law and just criminal law in general, deterrence, retribution, rehabilitation, that corporation hasn't done anything that any of us could think of is to do differently. It obviously cannot control 100% the actions of its employees. It can control all of its policies with respect to trying to deter and detect criminal activity by its employees. And yet, under the current state of the law, civil standards of agency principles are being used for criminal liability. What I and other people have done is looked for criminal cases around the country, and they're not that many, where a corporation has actually gone to trial so that this issue can be raised. The reason it is hard to find those cases is because under the current state of the law, it is really too much of a gamble for most corporations to roll the dice and go to trial. Because of the standard of corporate criminal liability, the power that the federal government has, and I used to enjoy that power, gave you an enormous club with which to exact a deferred prosecution agreement. And there's a panel later today about the dramatic rise of deferred prosecution agreements in this country. And I would submit that one of the main reasons is that a corporation rarely has a choice, because under the current state of the law, even the hypothetical gold standard corporation will have no defense. They have a lot of discretionary arguments to the Department of Justice, but they have no legal defense, even though they have done everything you can think of. So it's very hard to find the right case, or any case, where a corporation actually says, you know what, we're going to test the law in order to get up to the Supreme Court. Recently, in the Second Circuit, there was a case, United States versus Ionia Management, that where on appeal, this argument that New York Central did not decide the issue was raised. And that argument was bolstered by not just a lack of statutory authority and a lack of Supreme Court authority with respect to the statutes at issue there, but also by 3 Supreme Court cases in the civil arena. Right now, the standard for civil liability in the Title VII context is more favorable to a corporation than criminal liability. In 3 Supreme Court cases, 2 decided as companion cases, Farragher and Ellerth, in 1998, the Supreme Court was addressing the standard under Title VII for employer liability in hostile workplace cases. And in spite of a statute that explicitly said that it was calling for the application of agency principles, the Supreme Court rejected the application of strict civil agency principles and said that an employer would have an affirmative defense in that case to show that they had, among other things, an adequate system to address the hostile workplace environment, and that the employer whose conduct was the alleged offending conduct had to be of a sufficient managerial role for it to be fair to impute liability to the company. Those 2 cases are certainly ones that you can look to in analyzing this issue about criminal liability, but the following year there was a case that I think is even more illustrative, and that was Kolstad, which was decided in 1999, and there the court was dealing with, again, a Title VII case, but not hostile workplace environment cases, but instead just a standard sexual discrimination case, and was dealing with the issue of punitive damages. So you start getting very close, as the Supreme Court itself has said, to the reasons for criminal liability and the role of criminal liability. And there the court expanded on its decisions the year before and said for punitive liability to attach to a corporation civilly, it would be necessary for the plaintiff to show that the conduct was committed by a managerial employee, not simply by any employee. And moreover, that if the defendant could show that the actions of the corporation to try and comply with the Title VII laws were taken in good faith, that would be a complete bar to punitive damages. And the court expanded on the reason for that the role of Title VII and punitive damages was not to redress the harm to a plaintiff. It was looking at the traditional role of punitive damages, which it analogized to criminal sanctions. Obviously, as you can see, that provided good fodder for the Ionia management argument in saying that what is out there right now is federal common law, no Supreme Court guidance that is directly on point, 3 Supreme Court cases that strongly suggest the imbalance of the criminal law and the civil law. The outcome of the Ionia management case a couple months ago was the court saying essentially at oral argument that its hands were tied, but wouldn't this be a great case for the Supreme Court to go to hear? And it, of course, there was a list as long as my arm of Second Circuit cases that said that a corporate compliance program is not a defense and good faith is not a defense. So it was bound by all of its prior decisions. And I think that will be more or less the position of many circuit courts because of the rule of not overruling a prior panel. But this is a case that is ripe for Supreme Court review, particularly given the law on the civil side. And I think the reason for that imbalance is that there's so much more ability on the civil side to have these cases heard and decided, and for them to go eventually to the circuit level, to the Supreme Court. But this is one of those areas where it's capable of repetition but evading review, where it's very hard for a corporation to be that test case and guinea pig and not take the deferred prosecution and actually litigate